Thank you, Paul, for the very kind introduction. Before we begin, I'd like to acknowledge the traditional owners of the land on which we meet, and I also want to acknowledge the Australian Research Council, which has funded the project on which tonight's lecture draws, and my research associate, Tristan Harley. On Saturday, 29th of June, I read a media report about 8 men named Omar found dead on the streets of Baghdad. Their crime? The name Omar identified them as Sunni, and this was enough to mark them out for death. So I begin the lecture with 2 questions. First, if you were an Iraqi called Omar, would you stay in Iraq or would you seek refuge elsewhere? Second, if an Iraqi called Omar asked to stay in Australia, what would your answer be? 60 years ago, with the memory of World War II fresh in people's minds, the answer to these sorts of questions seemed fairly obvious. International law confirmed that there's a right to seek asylum and an obligation not to return a refugee to a place of persecution. Today, that consensus is under threat, even though asylum remains a fundamental safety net in a world where human rights are frequently violated. Over the last few years, Australia's government, whether we're talking about Labor or the Coalition, has been attempting to deflect asylum seekers arriving by boat to other countries. And in various ways, they've sought to justify what they're doing as a regional approach. For example, the Rudd government negotiated the so-called regional resettlement arrangements with Nauru and Papua New Guinea, while the Coalition has talked about a regional deterrence framework. In tonight's lecture, I'm going to explore the relationships between regionalism, responsibility and refugees. Do regional arrangements properly protect the institution of asylum? Do they fairly share responsibility for asylum amongst countries, or do the states nearest to refugee flows take the lion's share of responsibility? And finally, do Australia's policies enhance or retard regional cooperation in the protection of refugees? Regional efforts to protect refugees have a very long heritage. The major international treaty for the protection of refugees, the 1951 Convention relating to the status of refugees, which together with its 1967 protocol now has 148 odd countries as party, can itself be viewed as a regional document. It was conceived as a response to refugees in Europe displaced during the course of World War II and those fleeing communist countries after the war. The definition of a refugee applies to someone who's outside their country of origin and unable or unwilling to return owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion. It clearly captures the experiences of Jews fleeing the Nazis and responds by obliging states to provide protection. The Convention imposes the obligation of non-refoulement. International lawyers love French and Latin. This is the obligation not to return a refugee to a country where the person apprehends on good grounds that he or she will be harmed. Those who drafted the Convention were clearly of the view that to return a refugee to irreparable harm would implicate the authorities of the country in which asylum had been sought. To return a refugee, they said, would be tantamount to delivering him into the hands of his persecutors. In other words, we take responsibility for refugees because if we don't, we're responsible for what eventually may befall them. Since the Convention was adopted back in 1951, many other human rights treaties have extended the obligation of non-refoulement to other forms of harm, including torture and forced disappearance. And even in states that are not party to these treaties, it would be rare to find a statesperson who'd argue that it's permissible to return someone to those forms of harm. International lawyers now argue that there's an unwritten norm of international law, of customary international law, forbidding refoulement to torture and persecution. So the Refugee Convention has acted as an important precedent, establishing the universal principle that there are some situations to which we will never return a person because to do so would in some way be complicit in the harm that follows. Now, Australia, it is interesting to note, was the 6th country to become a party to the Refugee Convention back in 1954. This is significant for 2 reasons. First, it signals Australia's acceptance that the Australian government and the Australian people will not be accomplices to persecution. And second, the Convention only required 6 countries to become party in order for it to enter into force, to become binding law on consenting states. So Australia played a critical role in the development of international refugee law and the safety that it offers to people. Despite its universal significance, the Refugee Convention's origins in regional history were obvious when it was first adopted. The Convention originally contained a deadline of 1 January 1951, and parties could choose to limit their obligations to refugees fleeing events in Europe before that deadline. So it was both based on and limited to the European experience during World War II and its aftermath. These geographical and temporal limitations were lifted by the 1967 protocol relating to the status of refugees, which itself was responding to regional developments elsewhere. In particular, African countries were concerned by the narrow terms of the Convention definition, and they adopted their own refugee definition in the 1969 OAU Convention governing the specific aspects of refugee problems in Africa. And importantly, their definition includes refugees fleeing generalised violence, as well as those fleeing persecution for reasons connected to the 5 established grounds. Since this development in Africa, other regions have also adopted expanded definitions or extended a form of protection complementary to refugee status to those persons who are not fleeing persecution related to one of the 5 grounds, but who still require protection from some irreparable harm. In Latin America, the Cartagena Declaration on Refugees also extends protection to refugees fleeing generalised violence, and many states in that region have incorporated the expanded definition into their national law. While in Europe, a status known as subsidiary status is afforded to people fleeing generalised violence, although I have to say it's a fairly complex definition that generates a lot of case law about its precise ambit. In 2 other regions, Asia and the Pacific and the Middle East, although customary international law, that unwritten law applies, there are many states which are not party to the universal instruments, and there's also very little by way of regional refugee law. In the Asian region, we sometimes talk about the Bangkok Principles on Status and Treatment of Refugees, which was adopted by an advisory body, the Asian African Legal Consultative Organisation, but this instrument does not appear to have been widely implemented in national laws in the region. There's a reasonably new Asean Human Rights Declaration. It refers to the right to seek and receive asylum, but of course it's not a binding instrument. In the Middle East, there's an Arab Convention regulating status of refugees in the Arab countries, but it's not in force. And as with the Asia-Pacific region, we find many countries do not have national laws and procedures for the protection of refugees. On the other hand, it has to be said that refugees are in practice tolerated in those regions, and non-refoulement is widely, if imperfectly, respected. There have also been a number of regional arrangements that deal with other aspects of refugee protection, so going beyond the refugee definition, including the question of which state should be responsible for protecting particular refugees. Now, you may well ask, how does the question of who is responsible arise? Well, one of the great conundrums of the Refugee Convention is that while it protects refugees from return to a place of persecution, it does not explicitly offer a right of entry to any particular country, and many of the rights in the Convention are contingent on something more than mere presence in state territory. The right to work, which is as crucial to survival as protection from refoulement, is an example. A refugee must be lawfully staying in a country in order to engage in wage-earning employment, and their entitlement to do so is on the same terms as the most favourable treatment accorded to nationals of a foreign country. Now, in Australia, refugees are well protected because the foreign nationals with most favoured nation status would be citizens of New Zealand, and permanent residence. But that's not true in all countries. You can't find those sort of comparators. So you appreciate that the Convention establishes a relative standard and how careful the framers were to protect the right to control immigration and to protect citizens' access to the labour market and to other public goods. Refugee protection can also be thought of as a temporary status, contingent on the continuing risk of persecution. We talk about 3 durable solutions that are not necessarily enshrined in the Refugee Convention in so many words. They involve local integration into the country of refuge, return to the country of origin, which should be voluntary if the person's still a refugee, but if there's been a change of circumstances, so the person no longer fears persecution, it can be involuntary. And finally, we talk about resettlement in a third country. Consequently, states have invented the idea that a refugee may receive protection elsewhere, that they can go to a safe third country, or that they should return to a safe country of first asylum, the first place where protection from persecution could be secured. In the case of refugees who've arrived in contravention of national immigration law without a visa to enter Australia, for example, the Convention, although it says refugees should not be penalised simply because they've had to flee for their lives, does hint that protection might have to be sought elsewhere. So if you look at Article 31 of the Refugee Convention, it provides that restrictions on freedom of movement can be applied to people who arrive without a visa, as long as they're necessary, which is the big issue in Australia. And they can only be applied until their status in the country is regularised or they obtain admission into another country. So you see there just the hint that perhaps you could require a refugee who's unlawfully here as a matter of national immigration law to seek protection elsewhere. And so Australia does have a legal leg to stand on when it sends people overseas to have their claims heard or to be resettled. Now, if a state can't find another person to take the refugee will have to be admitted and afforded all the rights set out in the Convention. You can't keep a person in limbo and deny them lawful status under national law. It would make a mockery of the Convention. And there are many other human rights standards that apply to people, not because they're refugees, but because they're human beings. As a result, states have adopted a variety of deterrence measures in an effort to avoid responsibility for refugees. Those states willing and able to invest significant resources in border control ensure that it's not easy for refugees to migrate. There are, for example, less than 100,000 resettlement places offered globally in comparison to the worldwide refugee population that stands at about 12 million people. So less than 1% of refugees are offered a resettlement place. This has 2 consequences. First, if a refugee is in fact insecure in the country to which they first fled, they'll often have to use people smugglers in order to find meaningful protection. As my colleague Catherine Deverne argues, through border control, we make people illegal. A second consequence is that those states nearest the refugee flows shoulder most responsibility for sheltering refugees. And frequently they are the least capable hosts because they suffer from the same sorts of conditions as refugee-generating countries. If you think of the Middle East at the moment, we have Syria imploding in civil war. Egypt is expected to shelter Syrians. It has its own inner turmoil. Iraq is also expected to shelter them, and yet it's been overtaken by ISIL or ISIS. Now, the Refugee Convention doesn't actually help this kind of situation because it doesn't enshrine a legal obligation to share responsibility for refugees. It merely refers in the preamble to heavy burdens imposed by refugee protection, a term that's not particularly helpful because it defines refugees as a burden, whereas in fact they make huge contributions. So I want to consider whether regional efforts to share responsibility have made progress where the universal instruments have not. So what have the Africans done, for example? Well, the OAU Convention, that has that expanded definition, which I mentioned earlier, does contain a fairly weak provision concerning shared responsibility. So member states are able to call on other member states or through the OAU, now the African Union, and the member states shall, in the spirit of African solidarity and international cooperation, take appropriate measures to lighten the burden of the member state granting asylum. Unfortunately, this provision has not been adequately implemented in practice. In the European Union, a common European asylum system has been established, at least in law or on paper, even if its implementation is uneven. The focus of the common European asylum system is on harmonising among EU states the interpretation of the refugee definition, the procedures for determining status, and reception conditions, living conditions, for those seeking asylum. The EU has also established criteria for determining which state is responsible for assessing asylum applications under what's known as the Dublin Regulation. It also has an Asylum, Migration and Integration Fund for sharing financial resources, and it's run a small pilot relocation scheme to relieve Malta of some of the asylum seeker influx there. Tellingly, however, responsibility for unauthorised asylum seekers, those arriving without a visa, rests with the first EU state to which these unauthorised migrants gain physical access. And moreover, EU states are permitted within reason to send migrants outside of the EU. And then, of course, there are a raft of measures in place that ensure it's difficult for asylum seekers to enter the EU in the first place. So you can see then that Europe has been doing exactly the opposite of what the Africans want to do. The first focus on first entry means that EU member states do not share responsibility on the basis of capacity, but seek to leave responsibility where it first falls. And this has serious consequences for asylum seekers and refugees. Until recently, Greece received many requests for the return of asylum seekers, even though EU member states were well aware that Greece recognised very few refugees, subjected them to detention in dire conditions, and/or left them destitute on the streets. Meanwhile, Italy collaborated with Libya, of all countries, to intercept asylum seekers on the high seas. Fortunately, in the EU, there are regional courts to police what the Europeans do. So the wider Council of Europe has the European Court of Human Rights, and the EU has the Court of Justice of the European Union, and they put a stop to returns to Greece. And the European Court of Human Rights also ruled against Italy's collaboration with Libya to intercept boats at sea. And it's a very important precedent when thinking about what's been happening on the high seas with Australia, because the court there said, of course, your international obligations follow you out onto the high seas. So Europe, the birthplace of modern refugee protection, has a somewhat mixed record on responsibility sharing. What then of other regions? In Latin America, on the occasion of the 20th anniversary of the Cartagena Declaration, which has that expanded definition of refugees, a regional arrangement known as the Mexico Declaration and Plan of Action was adopted. Designed to respond to the Colombian refugee crisis, this is a visionary document designed to improve standards of refugee protection and to some degree to share responsibility for refugees based on a strong commitment to solidarity. There are 3 courses of action for strengthening protection of refugees under the Mexico Plan of Action: the cities of solidarity, the borders of solidarity, and resettlement in solidarity. The first pillar, the cities of solidarity, seeks to deal with refugees living in urban areas. The second pillar, the borders of solidarity, aims to increase the presence of state institutions, of UNHCR and civil society in the border regions of the countries neighbouring Colombia. And remarkably, the Mexico Plan of Action refers to the need to keep borders open in order to guarantee protection. This is very different to the language of border protection prevailing in the West, and very different to Australia's Operation Sovereign Borders. A noteworthy example of the borders of solidarity in action is Ecuador's 1-year enhanced registration program over 2009 to 2010, pursuant to which this fairly small developing country recognised 27,740 refugees, applying both the 1951 Convention definition and the expanded Cartagena definition. Unfortunately, there is a downside. In the aftermath of this really terrific move by Ecuador. They have resorted to restrictive policies for asylum seekers arriving at the border. So, deadlines and things to prevent people from getting refugee status. The third and final pillar of the Mexico Plan of Action is the Regional Solidarity Resettlement Program. 5 countries have participated, and while the resettlement numbers are tiny when compared with North America, that's the leader in resettlement, the program is an important symbolic step. Now, in the Middle East and in Asia, as I've said, there are no regional arrangements in place. UNHCR has adopted a quote-unquote regional response plan in response to Syria, but it's really not the same as the kind of regional arrangements I've been talking about. It's a UN-led project, and while there's been some responsibility sharing, an increase in some resettlement places and humanitarian assistance, in essence the states bordering Syria have been doing the heavy lifting. Many of these states tolerate the presence of refugees, although they don't necessarily grant lawful status under domestic law, which has all sorts of consequences in terms of right to work, education and so on. This may reflect a fear of pull factors, the idea that improving conditions will simply encourage more refugees and migrants, but of course the unintended consequence is the increased potential for corruption, smuggling and trafficking. Smugglers and traffickers play on vulnerabilities such as undocumented status. In the past, there was a major regional arrangement operating in the Asia-Pacific region, the Comprehensive Plan of Action for Indo-Chinese Refugees, or CPA, and that tried to ensure that lawful movement was available for the mostly Vietnamese refugees through an orderly departure program operating from Vietnam and resettlement from the countries of first asylum, Hong Kong, Indonesia, Thailand, the Philippines and Malaysia, to countries like the US, Canada and Australia. The CPA also aimed to ensure that those determined not to be refugees were returned without severe consequences to Vietnam, and there was extensive monitoring of returnees. This arrangement was clearly very significant, particularly in the way that it opened avenues for lawful movement from the country of origin and countries of first asylum, but it wasn't perfect. If the present European arrangements may be viewed as largely leaving responsibilities for refugees where they land, at the outer edge of Europe, the CPA has been described as passing the buck, handing on the obligation of refugee protection from the Southeast Asian region to countries of resettlement like the US, Canada and Australia. And I have personal experience of the RSD, or Refugee Status Determination process under the CPA, and I can tell you it was pretty inconsistent, and there were also many practices of deterrence. Most notably, mandatory detention was adopted, which the authorities described as humane deterrence. So you can see where Australia's policy has come from. Having worked in the Hong Kong camps, as Paul mentioned in the introduction, as a very young green lawyer, I can say that Whitehead Detention Centre in particular was not humane. This was a very forbidding place, surrounded by barbed wire, lots of corrugated iron, not humane at all. In addition, although the CPA had some very positive things about it, like the scale of resettlement, I really wonder whether that will ever be repeated and whether it's not just a legacy of the Cold War and the commitment to people fleeing communist countries at the time. And as for the orderly departure program, could that be replicated today? We're often not dealing with a repressive communist government, but countries that are failed states and really having difficulty controlling what's going on there. So it's really questionable whether you could have an ODP for countries in the Middle East, for example. So what does that picture paint then? Overall, we see regionalism manifesting as imperfectly implemented solidarity in Latin America and in Africa. And in both cases, we could also say that the origins of this solidarity reflect the largely intra-regional nature of the refugees. So in Latin America, we're dealing with Colombians. In Africa, we're mainly dealing with Africans. In Europe, we also see some problems with implementation. But the main problem with regionalism in that context is that there's a preoccupation with keeping undesirable, quote unquote, migrants at bay. As Matthew Gibney has written, this is engineered regionalism, whereby the global north reinforces its status and keeps the global south out. Meanwhile, with the CPA, we saw genuine sharing of refugees, but it seems unlikely that resettlement on that scale will be offered again, and there is no strong legacy of refugee protection established in Southeast Asia. And that, of course, has consequences for Australia. Australia finds itself an island in a sea of legal protection gaps. And as a consequence, asylum seekers arriving here by boat can claim protection from penalisation for their unlawful entry because the lack of protection elsewhere is a good reason for their move to seek protection in Australia. Unfortunately, Australia's response to this reality is often to rewrite its national laws so that they retreat from the advance of international law and to remove asylum seekers into some extra legal space governed by executive discretion and secrecy. And we can think of many examples. The excision of the migration zone of territories from the migration zone, and eventually, effectively, the excision of the whole mainland, and the present practice of expedited hearings on the high seas for Sri Lankan asylum seekers. Effectively, with the first strategy, excision, we pretend we're not at home, and we refuse to hear and recognise asylum seekers under the second, and the government refuses to tell anyone else what is going on as well. Not surprisingly then, our turn to regionalism has more in common with engineered regionalism in Europe than the regional solidarity of Africa and Latin America. So let's think about our various regional arrangements. So first of all, the Gillard government seized on the opportunity presented by UNHCR's efforts to insert refugee protection into the Bali process on people smuggling, trafficking in persons and related transnational crime. And they secured a regional cooperation framework. The core principles underpinning that framework are elimination of smuggling and promotion of orderly migration, access, quote, where appropriate and possible, to consistent asylum procedures, whether through harmonisation or regional arrangements which could include regional centres, durable solutions, return of people not in need of protection, and targeting people smuggling through border security, law enforcement and disincentives. So something of a mixed bag, but certainly there was potential in the RCF. Unfortunately, the process of diplomacy operate very slowly, particularly in this region, and Australian governments want results now, if not yesterday. So without really giving the Bali process time to work, the Gillard government returned to offshore processing on Nauru and Manus Island in Papua New Guinea, and the Rudd government concluded a couple of bilateral arrangements that seek not to share responsibility, but to shift it in the aim of acting as a deterrent to people seeking protection by unauthorised means. The so-called regional resettlement arrangements between Australia and Papua New Guinea and Australia and Nauru seek to completely transfer all responsibility, both for refugee protection and the durable solution of resettlement, to those two states. There are, however, a number of sleights of hand, both in the wording of the Memoranda of Understanding and in their implementation. Neither MOU, if you look at them carefully, actually obliges these countries to resettle all refugees transferred to them, and indeed this would just be impossible on Nauru. Nauru is a small island of 21 square kilometres. It has large swathes of uninhabitable land due to phosphate mining, and an island society which could be rather difficult for the few refugees who theoretically could be resettled there. The Chief Executive Officer of the Refugee Council of Australia, Paul Power, has quipped that if Nauru resettled only 6 refugees, it would overtake Australia as having the most generous per capita resettlement program in the world. As for Papua New Guinea, many people pointed out early in the life of these agreements that there are numerous problems relating to lack of private land, the largely monoracial society in Papua New Guinea, and high levels of violence. And tragically, we've seen that violence in play within the detention centre on Manus and the death of Reza Barati. In practice, it appears clear that Australia is effectively running the show, belying the claim that legal responsibility for processing and detention has passed entirely to Nauru and Papua New Guinea. Therefore, as a matter of international law, Australia cannot simply escape all liability for what goes on in those centres. And nor should Australia be able to get away with rebadging this as resettlement. In addition to the fact that the agreements seem unworkable in practice, what Australia seeks to do here is to subvert the system of refugee protection as we know it, and to put in its place something that moves us further away from the goal of fair responsibility sharing. Resettlement, as I've said, is not set out as a legal obligation in the Refugee Convention. It's a discretionary process that can be viewed as implementing a moral obligation to share some of the responsibility borne increasingly by the developing world. The statistics show us that the number of refugees sheltered in the developing world has increased from 70% to 86% over the last decade. So Australia has inverted the moral responsibility of resettlement by sending asylum seekers to developing countries in order to evade its hard legal obligations to offer asylum. And then, of course, another regional effort, so-called, the coalition government has engaged in unilateral pushbacks or towbacks of boats and the use of the infamous orange lifeboats to return asylum seekers to Indonesia. This is all part of the regional deterrence framework. There is, in fact, nothing regional or protective or responsible about this practice. And the message that Australia is sending to its neighbours is that refugee protection is too hard unless it can be completely controlled. Well, by definition, refugee flows are not controlled. Refugee status is an emergency status invoked by people whose lives and rights are under threat. They exercise some agency here, they need to be able to do so, but they are no more in control of the situation than we are. Regional arrangements may offer some prospects of making refugee flows more orderly at some point in the migratory process, but I doubt it's possible to impose complete control. And if every country insisted on complete control, then the ability to claim asylum, that fundamental safety net, would be gone. What regional arrangements should try to do is build on the bottom line of non-refoulement and aim to shore up and share responsibility. If Australia was serious about true regional cooperation on refugee protection that respects the institution of asylum, it would shoulder its own responsibilities without complaint, and it would support countries in the region to consider becoming the party to the Convention. Many things could be put on the table. One idea that I think is appealing is twinning resettlement places in Australia with local integration of refugees, or at least better rights protection for refugees in countries in the region. And arguments to support this idea would be that it might diminish the people smuggling trade, and it might benefit local economies where there is sometimes very high labour demand. But such negotiations take time, respect and patience. They also require Australia to show its own commitment to refugee protection. This requires compassion, and it appears that the Australian public's compassion for boat people or boat arrivals has waned. Now, politicians may reflect, reinforce or even generate a lack of compassion in the electorate, but whatever the relationship between the elected and the electors is, I think the present budget may contain a cautionary tale for the electorate. Be wary of allowing your representatives to run with the idea that compassion is expendable, lest you too find yourselves consigned to the category of expendables. Throughout the 2010 election campaign and the period of minority government, we saw a concerted effort to present the arrival of boats of asylum seekers as an emergency that meant we had to be cruel to be kind. We're now hearing a similar rhetoric about a budget emergency that means we cannot afford to be kind. The budget appears to have drawn out the bottom line for many Australians. At least where Australian citizens are concerned, there's a real concern for the vulnerable, the elderly, the young, the poor and the sick. What I want perhaps a little provocatively, to suggest is that it's no surprise that a government given a green light to treat vulnerable asylum seekers badly should turn around and treat vulnerable citizens badly. To recall a famous quote by Pastor Martin Niemöller, "First they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the trade unionists, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. And then they came for me, and there was no one left to speak for me."